Hello, everyone. We have opened the waiting room and are allowing everyone into the program, and we'll begin promptly at noon. To those of us who are with us, thank you for joining on time. We will be beginning in a few minutes at noon. We'll be starting at noon. I noticed that someone's commented there's no sound, and that's because we're just waiting for everyone to join the program. And I also noticed that someone's raised their hand. I don't know if you're asking a question or just waving to us all. If you've got a question, could you please type it into the Q&A box so we can address it? Okay, so the one question is, are you going to take attendance? I don't think we are. If you are concerned about reporting this to the Law Society, it's a self-reporting system. So you will just report your attendance at the program. And the other comment was hello, welcome back, or hello back to you. And it looks like we've got 1 minute until noon when we'll start. I see there's another question in the chat. Is there a video replay of this event? Yes, this event will be recorded and will be available afterwards. I'm going to have to defer to our friends at LexisNexis for details on that. Eric, maybe you can address that at the end. Okay. Well, my iPhone says it's noon, so I think it's time to get started. Welcome to Civil Appeals and Judicial Reviews. I'm Joan Rataic-Lang. I'm the Executive Director of the Toronto Lawyers Association. I would like to recognize that Toronto is in the dish with one spoon territory. The dish with one spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent Indigenous nations and peoples, Europeans and all newcomers, have been invited into this treaty in the spirit of peace, friendship, and respect. Today, our audience joins us from across Canada. The TLA respects and affirms the inherent and treaty rights of all Indigenous peoples across this land. Our speaker today, Marco Falco, has requested that we find out a little bit about our audience. So while I'm doing my introduction, a poll will be launched. So we'd ask that you could please complete the poll. Now, the TLA, the Toronto Lawyers Association, and LexisNexis have had a long working relationship providing quality education programs, and I know that today will not disappoint you. As I said, our speaker is Marco Falco. He is a partner in the litigation department at Tork & Mains, where he focuses on appellate litigation and applications for judicial review. Since 2019, he has repeatedly won Lexology's Legal Writing Award as a legal influencer in the dispute resolution area, both for his publications on appellate and civil litigation. Here's a sampling of some of his work that you may be interested in. Recently, he has published a number of articles on Lawyers Daily, top 5 considerations before seeking judicial review in Ontario, most common judicial review application mistakes, pitfalls of appeals and judicial review, what every litigator needs to know. Now, he is also a contributor to the litigation and dispute resolution module in practical guidance. His recent contributions include appeals and judicial reviews pitfalls checklist, common judicial review application mistakes checklist, considerations before challenging a tribunal decision. We obviously have an expert with us today. Now, I'd also like to add a little more information about him. Besides being a prolific legal writer, he is also co-chair of his firm's Diversity and Inclusion Committee and stands proudly as one of the first openly gay men to be named a partner at Tork & Mains. He advocates on behalf of LGBTQ2 Spirited Plus community to ensure that they have the professional mentorship and advancement support that they need. He has lots to share, and I'm sure you don't want to hear too much more from me. So just a few ground rules for how we will progress. We've got a lot of people on the program. Right now I see we've got over 300 online, and I know that close to 500 registered. So the latecomers will be coming. This means that the easiest way for questions to be handled is please type them into the Q&A box. Don't raise your hand. We can address questions verbally, and it's difficult for the moderator if we start having 2 streams. So please just use the Q&A box. At the end of the program, we'd love to hear what you thought about it. We will be redirecting you to a quick 1-minute feedback survey. And I know Lexis and the TLA both appreciate your feedback. Now I'm going to turn it over to Marco.
Thanks so much, Joan. Thank you all. So as Joan stated, my name is Marco Falco, and I am a partner in the litigation department at Tork & Mains in Toronto, where I've been practicing in the areas of civil appeals and applications for judicial review for the past 16 years. Number one, I'd like to thank both LexisNexis Canada and the Toronto Lawyers Association for giving me this opportunity to speak to a topic that is near and dear to my heart. A little bit of housekeeping before we actually launch into the program. We have a lot of territory to cover. The presentation may go over the 1 o'clock mark by a few minutes. So all this to say, don't feel at all hesitant. If you have to leave at 1 o'clock, we understand entirely. I will not personally be offended. We are all very busy people. So I understand if you do have to leave at 1 o'clock. So the purpose of my seminar today is essentially to share a series of practice tips and mistakes that I, myself as counsel, have made over the years. And I don't come to this presentation as being omniscient. I have learned from my errors, and I'm hoping that you'll learn from my mistakes as well. So this is a safe space where we do all make mistakes, and we understand that counsel makes mistakes. What I'm trying to do is hopefully give you some opportunities to learn from them. So with that in mind, I'm now going to share my screen and launch into the presentation, and hopefully you can all see it there. So here's the agenda for today. We're going to start off by looking at a general framework for civil appeals and judicial reviews. And the basic question that I want to address is, why are we here? Civil appeals and JRs are two different things, and they are very much fundamentally different creatures. So why are we addressing them in the same presentation? And what I'm going to do is take you through some of the commonalities, and then we will launch into parts 2 and 3, which talk about the common mistakes that I myself have made and others in both judicial review applications and in civil appeals. The final part will canvass written and oral advocacy as an art and a bit of a science. And I'm going to go through a series of best practices and in addition, touch upon some of the rules of professional conduct that essentially guide how lawyers conduct themselves during the course of both written and oral submissions to appellate courts. So let's begin with the framework and overview. What do JRs, and I will be using that as the acronym throughout, and civil appeals have in common? Fundamentally, the first point that I'd like to make is that both are reviews of a lower court tribunal decision or a lower court decision. So in other words, you're asking, in this case, the Ontario Divisional Court or the Ontario Court of Appeal for Toronto to review something. So something is fundamentally under review in both processes. The second important point to bear in mind about JRs and civil appeals is that both processes are not rehearings. They are not hearings de novo, where you get the opportunity to re-argue your case. In fact, what you're doing in a JR and a civil appeal, as we will discuss later on, is you're fundamentally trying to reduce your particular submissions to the basic 2 or 3 errors that were committed by either the tribunal or the lower court if you are the applicant or the appellant. And the third point is that the lens or the grammar through which the courts are going to assess the lower court decision or the tribunal decision is by way of the standards of review. So both civil appeals and JRs apply standards of review. Now, they may in fact be different, as we will discuss, vis-a-vis JRs as opposed to civil appeals, but fundamentally this is the grammar through which the courts are going to assess and analyze the particular decision under review. Now, you'll notice these are sort of 3 rudimentary building blocks. And what I'm trying to do is sort of establish a basic foundation, and hopefully we will get more complex as the discussion continues. So what is a JR? This is a 2022 decision of the Ontario Divisional Court, Robinson, which reminds all lawyers that a JR is fundamentally a discretionary remedy. And that is to say that the courts don't have to grant the relief that you are requesting. The second point about a JR that's critical is that what the court is ultimately assessing is a statutory power of decision. Now, in Ontario, that means that under the Judicial Review Procedure Act, the court is going to essentially analyze the exercise of a statutory power of decision. So the first question you have to ask yourself is, was the particular decision that I am seeking judicial review for made pursuant to a statute? Well, what is a statutory power of decision? Subsection 1.1 of the JRPA, as you can see, casts it in very broad brushstrokes. So it includes everything from a power or a right that's conferred pursuant to a statute, but it also encompasses things like legal rights, powers, privileges, immunities, duties, benefits, or licenses. That being said, there may be various decisions that are in fact not subject to judicial review. I personally have been involved in cases where I've tried to argue, perhaps unsuccessfully, as counsel for the applicant, that this was a judicial review because there was a private act of the legislature that incorporated a particular body, and therefore the decision that we are seeking review on was a statutory power of decision. In my particular case, the court didn't agree with that submission, but remember that fundamentally what you are looking for in a JR is that the decision under review is being made pursuant to an act. The other quirky thing about judicial review is that what you are asking for in terms of relief are what we inherited from England and what are known as the prerogative writs. We know some prerogative writs like habeas corpus and so forth, but in Ontario, there's three fundamental prerogative writs or remedies in the nature of these prerogative writs that the divisional court can typically grant. They include certiorari, where you're asking the court to quash the decision under review; prohibition, which asks the court to essentially ask the tribunal to cease doing a particular action, or the decision maker to cease a particular form of conduct; and then mandamus, and as the word sounds, if this obviously comes from Latin, you are asking the court to compel the tribunal to do something. And of course, that relief that you are seeking is going to be set out in your notice of application for judicial review. Now, this is in slight contrast to an appeal. And shockingly, when you think of an appeal, you think of courts and bodies like the Ontario Court of Appeal or federal courts of appeal, and you think they have all the power to do what they want. But weirdly enough, an appeal has to be grounded in a statutory right of appeal. And that is that there is no inherent right to appeal anything in Canada. And that express statutory right of appeal can derive largely from the governing statute or by statutes within the provinces across Canada that govern the rules of civil procedure. In Ontario, it's what we call the Courts of Justice Act. That is where you derive your express right of appeal. Now, with an appeal, you have to contemplate what the remedy is that you're asking the court to do if you are the appellant. Are you asking them to set aside the lower court or tribunal decision? Alternatively, are you asking them to set it aside and then remit that matter back to the lower court and tribunal for reconsideration in accordance with the court's reasons? Now, unlike a JR, this is somewhat intuitive, you start an appeal by way of a notice of appeal. And in Ontario, there's an additional quirk, and this is a little bit of a practice tip. You also have to include with your notice of appeal, typically, a certificate respecting evidence. It's not a lot of work as counsel, but essentially you have to set out the record from the tribunal or lower court below and what evidence you will be relying on in the appeal so that that's clear from the outset. And if, as the respondent, you receive one and you feel that the appellant's certificate is somewhat lacking, you can contest that. So that's the framework by which we are going to be analyzing these two spheres of judicial review and appeals. I'm now going to launch into some of the common mistakes and pitfalls vis-a-vis judicial review applications. The first and most common, and I promise you the Ontario Divisional Court is very attuned to this, is starting a premature judicial review application. You'll see from the Bannis decision below that the Ontario Divisional Court fundamentally hates when counsel breaks up a lower court proceeding or a tribunal proceeding by way of judicial review. And that's because they don't like getting involved until the lower tribunal proceeding has run its full course. And you can see the fundamental rationale behind this is things like avoiding fragmentation of the administrative process and delay, and also because courts have to naturally show respect for the legislature's decision to essentially confer that decision-making authority on the decision maker, the administrative decision maker, or the tribunal itself. So the courts, in particular the divisional court, if you try to come to court and launch a JR midway through a hearing, will ask you almost fresh off the bat, sometimes by way of email, if the particular JR is being case managed, is this an exceptional circumstance in which the JR needs to be heard at this moment right now? So what are the types of exceptional circumstances that justify a judicial review mid-hearing? These are some of the criteria, though not all, that the court will consider in deciding whether or not your JR may in fact be premature. Would there be some form of irremediable prejudice to continue with the tribunal hearing and not run to court first? And this can involve arguments about procedural fairness and due process that could be violated if the JR is not heard now. A second question the court asks is whether or not it needs to resolve the issue right now. Is there some absolute necessity to this? And is the delay to the tribunal proceeding that will inevitably be caused by the JR significant? Another common error for judicial review is missing what I call, and I put this in quotation marks because we have to be careful here, it's not an official limitation period, but there is a period of time by which a judicial review application, particularly in Ontario, has to be brought. Now, I am old enough to recall the days when this was essentially established by common law, and you'll see in the Jeremiah decision, which I quote in this slide, that essentially you had 6 months to bring your JR application on from the date of the tribunal decision. Well, that's changed in Ontario as a result of recent amendments to the Judicial Review Procedure Act. And now you effectively have a 30-day deadline to bring your judicial review applications. And this applies to all judicial review applications in Ontario, unless, of course, another statute says otherwise. Adhere to this deadline as the applicant. You do not want to be in the position where you have to bring a motion to extend the time to seek the JR. Now, sometimes it's inevitable. Your client comes to you at the 11th hour, and so you may have a late JR and so forth. But you don't want to be in that situation where you could be accused of professional negligence. As the applicant, you definitely want to adhere to that deadline. Now, should you find yourself in the unfortunate position of having missed the 30-day period, there is a bit of a saving grace. Section 5 sub 2 of the JRPA allows the court to extend that 30-day period, but this is why I'm saying you don't want to be in this predicament. You now have to show that you have apparent grounds for relief, that fundamentally your judicial review application has some merit, and that there won't be any substantial prejudice or hardship caused by the fact that you missed that particular 30-day period. So it's critical, again, that you don't want to end up in this position. You don't want to have to call your professional liability insurer and say, hey, I missed the 30 days. What do I do now? Are you going to take over the file because I missed it and perhaps bring a section 5 sub 2 motion? Those are not circumstances you want to be in. A third mistake from a practical perspective with judicial review applications is failing to identify the standard of review. Sometimes you think, well, the Ontario Divisional Court or the Ontario Court of Appeal surely knows its standards of review. Why do I have to identify it? Well, you must, as counsel, bring it to the court's attention and argue a particular position. Thanks to the Supreme Court of Canada's 2019 decision in Vavilov, which sorted out a number of issues that had arisen since the Dunsmuir decision with respect to standards of review. We now know that you have effectively two options in terms of arguments and the lens through which the court will assess the lower court decision. You can either argue that your particular decision should be subject as the appellant to reasonableness review, which of course will show significant deference to the tribunal, or correctness review, where there is less or no deference. For those of you who have pored through the lengthy decision in Vavilov, you will know, however, that Vavilov now creates a presumption of reasonableness review in all cases. So 9 times out of 10, the court's going to want to defer to the tribunal's decision in your judicial review application. That's not to say, and of course the court in Vavilov was quite careful about this, that reasonableness review is simply a rubber stamp. The court still has, even within the ambit of reasonable review itself, the ability to review the decision and question it, of course. Now, Vavilov said there was a presumption of reasonableness review, which means that that presumption, of course, can be rebutted in, I would argue, rare circumstances. And Vavilov essentially creates 2 umbrellas by which that reasonableness review standard can be rebutted. The first is where the legislature has indicated that a different standard of review applies. Well, how does the legislature do that? Well, either the statute expressly says, hey, this is the standard of review that applies to a judicial review application from this particular tribunal's decision, or there is a statutory appeal mechanism, in which case, if there is, you are not in judicial review territory because you have a right of appeal. And we'll talk about the standards of review that apply in appeals later on, but that's something to keep in mind. The second circumstance where Vavilov identifies that the reasonableness form or standard of review can in fact be rebutted is where the rule of law requires correctness review to apply. And so the courts are not going to defer to certain categories of legal questions that were adjudicated by the tribunal. What types of legal questions? Well, constitutional issues, surprisingly, are within the ambit and bailiwick of the courts. So they're not really going to defer to what the tribunal has to say on constitutional issues. General questions of law, quote unquote, of central importance to the legal system. I have to imagine that that means questions of law that obviously extend beyond the parties and will have serious implications for Canadians at large. And then questions regarding jurisdictional boundaries, for example, between two tribunals. Courts won't show as much deference when you're raising a jurisdictional issue. Now, what we've talked about in terms of JR to this point is substantive review. And that's where the courts look at the decision and they decide whether or not it was reasonably made or it was correct. A really good ground, if you are the applicant, for challenging a tribunal decision, in fact, is whether or not there was a failure of natural justice or procedural fairness, or what Americans call due process. Broadly speaking, if you can show a violation of natural justice, my personal view is you stand a greater chance of succeeding as the applicant on an application for judicial review. I'm not going to go through Administrative Law 101, but you know what these breaches of procedural fairness and natural justice tend to look like. They will affect things like the right to be heard, the right to be provided with reasons for the decision, and you'll know from Baker and Canada, that's a very low standard, and the right to an unbiased decision maker. If the decision-making process somehow gives rise to a reasonable apprehension of bias, you might have grounds for challenging it on a judicial review application. Another thing that you should realize, and I tell this to clients often, is yes, you can win your JR, and wouldn't it be fantastic if we did? But as Vavilov has now clearly established, more often than not, if you are successful on a judicial review application, it will be appropriate to remit the matter back to the decision maker and have that decision maker reconsider the decision, this time with the benefit of the court's reasons. What that ultimately results in is perhaps a hollow victory. So here you are, you've argued through the tribunal level, you've now gotten to Div Court quashes the decision. What does it do? It sends it back. Well, you might be back at the tribunal for another hearing. And from a pragmatic perspective, this means advising your client of the potential for that, because 9 times out of 10, that is exactly what the court is going to do. And there are a series of economic factors, delay, and so forth that will go into the client's calculus as to whether or not to pursue a judicial review application. But you as counsel have a duty to explain this to your client when you are conducting a JR. Now, there are, of course, limited scenarios where the court's not going to remit the matter back, where the court essentially says, look, you've won your JR, we're going to quash that decision, and we're not sending it back. And they do so, Vavilov identifies, in circumstances where there essentially would serve no useful purpose, because the particular outcome is just so obvious on its face that there's no point in sending it back to the tribunal for reconsideration. And some of the factors that the court will consider in remitting the matter back to the tribunal are things like delay, fairness to the parties, urgency, the nature of the regulatory regime, whether or not the original decision maker really had a genuine opportunity to weigh in on the issue, costs, and of course, a primary court concern, the efficient use of public resources. One of the final errors that I want to point out on a JR, and this isn't necessarily particular to Ontario, though it is a function of the Judicial Review Procedure Act in Ontario, all judicial review applications in Ontario must be served on the Attorney General of Ontario. And in your first few years of practice, you can miss this. It's incredibly important because the Attorney General has a right to essentially intervene in every Ontario application for judicial review that is out there. And you will get notice from the Attorney General when you commence a notice of application for judicial review and you serve it upon them as to whether or not the AG really feels that it needs to get involved. But it is a key step, and it is codified under the governing statute, that you must serve the Attorney General with that application for judicial review. Or sorry, the notice of application for judicial review, rather. The other thing is that if your judicial review application also involves charter or constitutional issues, i.e. division of power issues, you are required in Ontario under the Courts of Justice Act to serve all notices of constitutional questions on both the Attorney General's Canada and Ontario. That's a key point, something that's often missed, but if you are raising a charter challenge or some form of a constitutional issue within the context of your JR, it's something to bear in mind, because if you fail to do so, it could actually be fatal to your JR. And again, not a mistake you want to make. So very quickly, I'm just going to run through the 6 or so errors that we've identified. You want to make sure that you're not starting your JR too early. That being said, if you are going to bring a JR, you must make sure that you adhere to that 30-day deadline. Make sure that if you are the applicant on your judicial review, and even if you are the respondent, that you make an argument to the court about the applicable standard of review. If there is a breach of due process, procedural fairness, natural justice, whatever you want to call it, make that argument. It's really important. Take a position on whether or not you feel that if you are successful as the applicant on a judicial review application, that the matter should be remitted back to the tribunal. And don't forget to serve the Attorney General. So those are the particular errors I've identified over the years, and certainly I've been guilty of a few in the past with respect to judicial review. As we discussed at the beginning, while JRs and civil appeals broadly have some similarities, they are two very different processes by which to review a tribunal or lower court decision. So you're going to see immediately there's going to be some overlap in the types of typical errors that counsel makes when they launch into civil appeals versus judicial review, but there will be some fundamental distinctions, and we'll get through that. With an appeal, the worst thing that you can do is fail to identify the source of the court's jurisdiction. Once again, and I quote the Sutcliffe decision of the Court of Appeal in this matter, there is no inherent right to appeal, which comes as a shock to a lot of parties and to a lot of counsel. So appeal rights are wholly a matter of statute. You need to find the statute that gives the appellate court the jurisdiction to intervene in your particular matter. So, assuming you find that statute, what do you do? Well, you have to look at the statute carefully. Do you have a right to appeal, that is, go straight to that appellate court to challenge that decision? Or does the statute require you to bring a motion for leave to appeal? And why do we have motions for leave to appeal? This seems like a cumbersome additional process, but the reason that we do is because the appellate courts in Ontario and across Canada have identified certain types of issues and questions and proceedings that they don't really want to hear appeals on, and they certainly don't want you fragmenting a lower court or tribunal decision just to run to court to have your appeal heard, in which case they add the additional hurdle or onus as the appellant to bring a motion for leave to appeal. Now, in Ontario, this with the caveat that you always have to look at your governing statute. But in Ontario, very generally, appeals from interlocutory orders typically require leave to appeal, and appeals from final orders don't. So, because in Ontario, determining whether or not you have to go straight to the Court of Appeal or you have to bring a preliminary motion for leave, which is typically heard in writing, in order to determine which way you basically have to go, one of the first things you have to do is find case law to determine if your order is final or interlocutory. Now, having done appeals for a while, sometimes I will talk to lower court counsel and, their immediate gut reaction is, of course, this order is final. Don't rely on your instinct and gut there. Go into the case law and find it, because you will be surprised what is considered a final versus an interlocutory order, and which appeal route you really have to take. Generally, at common law, a final order is one which disposes of the litigation or finally disposes of part of the litigation. This looks very much, for those of you who studied math, like a series of coefficients. It doesn't actually do much other than establish a principle. An interlocutory order, of course, disposes of the issues raised, most often a procedural issue, but the litigation is ongoing. Again, this is the test that the courts apply. But if you have a motion for summary judgment and that motion was dismissed, then you should find case law which firmly establishes whether or not the dismissal of your summary judgment motion is considered final or interlocutory. Making a mistake on this could be fatal, because if you go to the wrong place, you've now missed the deadlines for the other place, and you're stuck in a quagmire of trying to undo your mistake. And again, that raises the potential for lawyers to have to contact their professional liability insurers and report. So, final versus interlocutory orders, as I said, don't make the assumptions. There's another issue that can arise when you're trying to decide whether or not the order that you are seeking to appeal is final or interlocutory in nature. I don't recommend it because I personally hate it. The courts hate it. No one likes to create a multiplicity of proceedings. But if you're absolutely unsure, you've looked at all the case law, you have no idea. This could go both ways. It could be final, it could be interlocutory, who knows? One thing that you could do is commence effectively a motion for leave to appeal in the one appellate court that requires you to do so. Start a notice of appeal in the second court, have them go simultaneously, but hedge your bets on one or the other and ask the other court for permission to hold the one that you're not pursuing in abeyance. So you're basically saying, can we just put a hold on this motion for leave to appeal? Because fundamentally, I believe this was a final order and I have a direct appeal as of right to the Court of Appeal. But if I'm wrong, Divisional Court, I've got this motion for leave to appeal out here. I did seek that motion on time. And so there won't be an issue if for some reason jurisdiction of the appellate court ends up being an issue at the hearing. Again, I don't recommend doing this because I hate starting proceedings, but sometimes you have no choice in the matter and you don't want to make the mistake of hedging your bets only in one court and then finding out that that appellate court has determined it doesn't have the jurisdiction to hear your appeal. So, related to the issue of the court's jurisdiction on an appeal, if leave to appeal is in fact required and you do have to bring a motion, do you satisfy that test? There are a whole gamut of tests that apply on motions for leave to appeal. This is just one of them vis-a-vis interlocutory orders where another statute doesn't apply in Ontario. You can see the immense hurdles that you have to face as the moving party. They are two parts. There's a two-part test, so you can show one or the other, but within those parts, there are two requirements. So you can show that there is a conflicting decision by another judge in Ontario or another court in Ontario or elsewhere, and basically the panel believes that it's desirable that leave be granted, or there appears to the panel hearing to be good reason to doubt the correctness of the order, i.e. you're arguing that a fundamental error was committed, and the proposed appeal involves what I call the public importance test, but what the rule actually says is matters of such importance that leave to appeal should be granted. In other words, what you're seeking leave to appeal on appeals to more people than just the parties who are intimately involved in the case itself. There's some sort of public interest component to it. You can imagine this threshold is high. Fundamentally, when the court hears the motion, at least in Ontario, most of these motions are heard in writing, and it is very rare that oral submissions will be requested from the court. And even if they are, likely the only decision you're going to get is leave granted or leave denied. So it's an expensive process to undertake, and therefore you have to contemplate seriously if you do want to seek leave to appeal. Okay, let's move on to the second error. Another error, which is again typical of JRs as well, is failing to bring your appeal or your motion for leave to appeal on time. As the appellant or as the moving party on a motion for leave, I cannot stress how important it is to bring your motion or your appeal on time. It can be utterly and completely fatal. If you don't, it can amount to professional negligence. And I can promise you that if you try to file or issue a notice of appeal or notice of motion for leave to appeal late in Ontario, counter staff will reject it, and then you will find yourself in motions territory where you're going to have to persuade the appellate court to grant an extension of time. If you do so, there is certainly a case to be made that you should contact your professional liability insurer at that point because you've missed a deadline. And either you or the insurer will then take it upon themselves to argue a motion to extend the time to file your appeal or motion for leave to appeal. What factors does the court consider in deciding whether to extend that time? Nothing surprising here. This is a 2021 decision, Canadian West Trust. Did the appellant actually have the intention to appeal within the relevant appeal period? Is there an explanation for why you missed the particular deadline? Is there any prejudice to the respondent now that the appeal or motion for leave to appeal is late? What are the merits of the appeal? And effectively, does the interests of the case, which is a general catch-all, require the appeal to be heard? A third typical error is failing to consider whether or not your appeal needs to be expedited. And by expedition, we mean that the appeal has to be heard quickly by the appellate court. Now, what you don't want to do is bring frivolous appeals before the court and argue that, my client has been harmed and this is urgent and you must hear this. You better have a good case to make as to why your appeal needs to be expedited. In Ontario, there are certain types of appeals, not surprisingly, which have been recognized by the court, and this is the Court of Appeal, for example, as being of such a fundamental important nature that the appeal should be expedited. This includes things like family law appeals, of course, where there are child welfare issues at stake, appeals under the Child, Youth, and Family Services Act is wrapped up in that, and any appeals that can basically delay the progress of an ongoing proceeding may in fact be expedited because there is some sort of tribunal or lower court proceeding that needs to run its course, and it's now being stopped by this appeal. So the court will say, hey, in that case, we are going to expedite this appeal because we don't want to cause further delay in the proceeding below. Now, of course, if there is no automatic expedited appeal and you think you have a very good case to make, then you have to bring on a motion. You can see the sort of general test that the court applies in deciding whether or not to expedite an appeal. Appeals are to be expedited only where the motions judge is satisfied about the urgency of the matter and you need an earlier hearing date. Another common error is, as the respondent, failing to bring a cross appeal within time. Now, generally, in terms of deadlines, the onuses are largely on the appellant or the moving party, the person bringing the particular appeal on. And courts obviously enforce deadlines and so forth, but they're not as fussed when you're the respondent as to whether or not you're responding within the timeframes. And I say that as a general rule. There are exceptions, so I don't want to convey the message here to ignore respondents' deadlines. That's not what I'm saying at all. You should adhere to them. But if you are the respondent and you are now cross appealing on the appeal, then you are effectively an appellant. In Ontario, that typically means under Rule 6107 of the rules that you have 15 days to serve that notice of cross appeal. And that is not a deadline that you can miss. So do bear that in mind, that 15 days is triggered from the date that you're served with the notice of appeal. And it may be different depending on which statute applies. This is a general rule. Okay. This error may in fact look familiar, failing to argue and identify the standards of review. Again, this was something we saw in JRs, but because of Vavilov and a previous decision called Hausen, different standards of review apply on appeals. And with appeals, the applicable standard of review really depends on the nature of the question that's before the court. If it is a question of pure law, then you can imagine that the deferential standard, the less deferential standard of correctness is going to apply by the courts. And that's because appellate courts are typically used to wading into the waters of creating and establishing law. This is not unfamiliar territory to them. However, if you are raising questions on your appeal that involve fact or mixed fact and law, where a legal question isn't extricable from that question of mixed fact and law, then you can imagine that the appellate court is going to show more deference. And that deferential standard is what is known as the palpable and overriding error standard. And again, these are standards of review that only apply where you have a right to appeal. Another error that's key is failing as the respondent to bring a motion for security for costs. If you are on the other side of appeal and you fundamentally believe that the appellant is bringing their proceedings, shall we say, in bad faith and not for the right reasons, or there's little to no merit to the appeal, they're simply bringing the appeal to delay the process, then one of the tools that you have in your arsenal is to bring a motion for security for costs for the appeal. Of course, what you then have to meet is a very high threshold, you can imagine, because now the appellant has to pay money in order to pursue its appeal. So you can imagine that courts are somewhat reluctant to do this unless there is a legitimate case for doing so. And appellate courts will effectively grant security for costs where it appears that the appeal is frivolous and the appellant lacks that ability to pay an adverse cost award down the road should the appellant be unsuccessful on the appeal. And there's the test from a recent decision of the Court of Appeal, Richardson, that basically sets out how the court approaches the task of deciding whether or not to order security for costs against the appellant. Is the appeal frivolous and vexatious and the appellant doesn't have sufficient assets? Should there be another good reason to award security for costs? And then there is this sort of second part to the analysis, which is what the court calls a holistic analysis, where the court assesses the circumstances and decides whether, on the whole, it's in the interests of justice or not to award security for costs against the appellant. Yet another error, raising or not raising new issues on appeal. You can imagine that appeal courts do not like when appellants raise new issues, particularly issues that you could have raised in the tribunal or lower court proceeding. And this is obviously grounded in due process concerns because that tribunal or lower court didn't have the opportunity to adjudicate on an issue that you are now trying to bring forward as the appellant before the Court of Appeal for the very first time. So in order to meet this very high threshold, if you intend to raise a new issue on appeal, you're required to show as the appellant that all the facts necessary to address that new point are in fact before the court so that the court could adjudicate it. And you can imagine, this is based on the two decisions of the Court of Appeal cited below, that if you're raising a new issue, but it's one of pure law, you probably stand a better chance of advancing it before the Court of Appeal. Why? Again, because on questions of pure law, the courts wouldn't have to defer to the tribunal or to the lower court necessarily. And so in the rare circumstance where they have to hear your new legal issue for the first time, they may be inclined to hear it. A practice tip error, and this can actually happen quite a bit, is failing to have the underlying order, typically a court order, from which you are seeking to appeal, have it issued and entered by the court. As the appellant, and I warn you because counterstaff are militant about this, if you do not have that underlying order, you won't be able to get it at a later time, start your appeal and so forth. You will miss your appeal deadline. So one of the first things that you want to turn your mind to when you are seeking to appeal something is whether or not you have the underlying order of the court issued and entered. Now, with tribunals, the same form of reasoning does not apply because typically tribunals only issue decisions. Within those decisions, they order things, but you don't get a stamped order typically from a tribunal. That changes with a court. So if you have to perfect your appeal, let's say within 30 days, for example, as the appellant, you have to factor in that I've got to give the lower court time to have that order issued and entered, which, as you know, in a clogged up legal system can take quite a bit of time. So it's one of the first things you do have to turn your mind to. Another error, doesn't come as a surprise. I sort of heckled you when I said that you were the applicant on an application for judicial review, and I'm going to say it again. If you are the appellant, don't commit professional negligence. Make sure that you bring your appeals or motions for leave to appeal within the prescribed times. Now, generally, it's the governing statute that tells you how much time you have to appeal. It's not always the statute that governs civil procedure in your province, which governs your particular matter. For example, there are a whole myriad of appeals set out in, let's say, the Regulated Health Professions Act in Ontario, in which case the appeal rights that are set out in the CJA and the rules don't necessarily apply because you're operating under a different act. In terms of perfection deadlines, you also have to adhere to those. Generally in Ontario, and again, I say that it really depends on what statute you're operating under. If there's no transcript required for the appeal, you have 30 days to file that notice of appeal. And if a transcript is required, you may have a bit more time. And of course, here are all the factors, once again, that the court is going to consider if you have to bring a motion because you missed your appeal at time. Again, as counsel, you would have an obligation to consult with your professional liability insurer. I'm not going to go into those factors. They echo many of the ones that we discussed with judicial review. So, in summary, you see the errors that you can make. It's a bit of a minefield. Don't get intimidated. I'm not going to go through these again, but there are a good 9, and I'm sure there are more that we could identify. Again, careful, cautious advocacy is what you have to practice when you're engaging in appeals. And of course, consult people who have done this before. And that's sort of a primary message that I do want to get across. If you've never waded into the waters of judicial review and appeals generally, do so carefully. And do get advice as counsel, whether you are the appellant or respondent, from someone who has practiced in the area before. Okay. So we've now looked at all the sort of common pitfalls. Let's turn to a bit of a lighter note, and let's look at some of the best practices and ethical implications vis-a-vis civil appeals and judicial reviews. And this will turn to issues about written and oral advocacy, but also certain duties that you have. So you want to start a JR or an appeal. First thing you're going to do is research your case. I don't care how much research you did at the tribunal level or at the lower court proceeding. The law may have changed since the decision was rendered, since you last appeared before the lower court or the tribunal. And you have a professional obligation under the rules of professional conduct, as I've cited here from the Law Society of Ontario, to do proper legal research and never to misrepresent facts or law. There is nothing more embarrassing than appearing before an appellate court and then finding out that the very decision on which you have rested your entire case was overruled by the Court of Appeal a week prior. So even in the process of drafting your factum, which we'll talk about shortly, and presenting for oral advocacy, note up those cases, because you don't want to be in a position where you're embarrassed because you've missed a key principle of law. Of course, in the process of researching your case, the one things that you have to bear in mind is that you can't ignore binding appellate authority. So even if a Court of Appeal decision isn't particularly favorable to your client's position, you advance it, you distinguish it, either in your written or oral submissions or both, but you do not ignore it. You are duty bound to bring that appellate decision to the court. Okay, factum drafting. Now, obviously, I'm going to go through this very quickly. This could be the subject of its own CPD program. So I'm just going to sort of touch on my general approach with some practice tips and go through this very quickly. This is how I approach drafting a factum. It may not work for you. This is what I like. Number one, start off with your issues. Identify 1 or 2 or 3 legal issues tops that you want to advance before the court. I then like to start by researching and drafting the law so that I understand the legal framework in which I have to set out the facts. Following which, I then go into the facts section. I look at the affidavits, cross-examinations, transcripts, and so forth, and pluck the best facts out that now match with my legal analysis. After I've done that, I go back into the law section, and I'm sorry this appears convoluted, but this is how my brain works, unfortunately. I go back into that law section, and I now start to draft the argument, which is probably the most important part because you are now applying the facts to the law. And then finally, the most important part of your factum, that overview. You do it last. You do it after you've spent several days ruminating over all the issues. And remember, it's your best argument first before the court. Now, I don't want to get into too much detail because we are coming closer to the end of this seminar. But in terms of the overview, some fundamental things that you do need to set out in your factum. And remember that as a piece of written advocacy, the factum is often more important than the oral submissions. It's the document that the judges are going to have in their possession from the moment you commence your appeal and perfect it to the point that they have to write their decision. They are frequently, and many appellate judges will tell you this, more reliant on your factum than they are on your oral submissions. So invest your time in the factum. With respect to the overview, what you want to indicate is, number one, fresh off the bat, why are you there? What type of relief are you seeking? Are you seeking to quash an order? What does that order say? Introduce the court to why you are there in the first sentence. Don't leave that as a mystery. I personally am of the view that I know that some people like to wax and wane poetical about various grand legal theories within the first sentence. My view is that's not the place to do it. Explain why you're there first, and then go into your theory of the case. The length of an overview can vary. Sometimes it can be as short as a few paragraphs. Sometimes it can spill between 2 to 3 pages. But remember that the overview is the most important aspect of your factum, because, of course, it is your opportunity to make a first impression. In terms of the facts, don't retell the entire case. Pluck the essential and discrete facts that apply to the legal errors that you are alleging on review. And you may want to look at certain data-driven legal tools that essentially could inform you about things like the way that judges have adjudicated similar facts to your own in the past. And that would actually give you a good sense of, how your particular appeal will be adjudicated. With the law section, obviously, as I said, note up, note up, note up. Make sure your law is up to date. Use quotations for only the most important decisions. Set out the legal tests, and you don't have to make this as a law school paper where you have to get into the facts of every case that you are planning to discuss. Only discuss those cases whose facts are most relevant. Very quickly on oral advocacy, some practical tips. To the greatest extent possible, cooperate with opposing counsel. The type of bombastic rhetoric that you see on television and sometimes is employed in lower court proceedings is not appreciated on appeal. You are reminded under the rules of professional conduct by this slide that you owe your opposing counsel a duty of civility. And appeals generally are very civil processes. Cooperate with counsel. Be aggressive and assertive in terms of your client's position, but don't be unnecessarily so. Now is not the time to engage in bombast. It's to make concise and cogent legal arguments to try to persuade through rhetoric. And that means having a collegial or cooperative relationship with opposing counsel. During oral arguments, some very practical tips as we wrap up. Don't reread your factum. These are very smart judges. I promise you they have read your factum. Now is the time to get into the heart of the matter. When you start, your oral submissions, always make sure to give a roadmap to the court. These are my 3 submissions. This is where I am taking you. This is the argument I'm going to make. Don't leave it up in the air. Again, you do want to get into the equities and so forth, and you can, but up front, judges appreciate when you say, these are my 3 points that I will be discussing today. Look at your opportunity for your appeal as a discussion with the appellate court. They're going to ask you pointed questions. Rehearse your submissions. Try them out on your colleagues. Don't sort of go there for the very first time, having prepared the night before and never considered your issues. Another practice tip for oral advocacy: be prepared to know your case inside and out so that you can deviate from the roadmap. One of the sort of bad ways to advocate an appeal is to get caught in a question by a judge and say, oh, I'll answer that in a second, or just a moment, Justice so-and-so, I'll get to that in about 10 minutes. No, answer the judge's question immediately. And how do you do that? You have to know the case well enough that you're prepared to jump back and forth in your submissions. That also means that your notes should facilitate the ability to do that. Be calm, measured, and slow in your delivery. Remember that judges are writing or taking notes, and especially at the appellate level where you're facing 3 judges, they might be writing at different paces or engaged in your case at different levels, in which case you want to speak slowly and make sure that your cogent submissions are getting across. If you don't understand the panel's question, politely ask them to repeat it. The Ontario Court of Appeal reminds lawyers not to refer to judges as your honor, my lady, my lord. That archaic stuff has sort of gone out the window. Do not use gendered language. Refer to the panel as the panel and refer to individual justices as Justice so-and-so. Okay. So with all that said, I'm now going to turn it over to Eric, who may have some questions. Again, it looks like we're going over by a few minutes. So if you have to drop off at all, do not hesitate to do so. And vis-a-vis any questions, no question is a silly question. So feel free to ask this. This is indeed a safe space. Thank you.
Thank you, Marco. That was great. Lots of questions in the chat and in the Q&A. I'm going to start with a few. There's a lot of questions around the 30-day limit for filing for judicial review, and a lot of concerns about that. Let me give you the first one. If you have an interim decision of a tribunal, but not a final decision on the substance, when does the 30-day limit start?
So really interesting question. And I think the courts, since that new amendment to the JRPA was made, I just recently encountered this with 2 of my partners at the firm, where we did have what ultimately turned out to be an interim decision in the eyes of the court. But you are faced with that 30-day period. There is something in the practice direction, don't quote me on this exactly, but I know I saw it, in the Ontario Divisional Court's practice direction, which seems to suggest that in that case where you were somewhat concerned about whether or not your decision is interim and final, that you actually commence the notice of application for judicial review. And then within that commencement, when you're drafting your lengthy email to the court explaining the nature of the JR and so forth, you make a request to hold that JR in abeyance. Now, I'm not saying to do that typically. This should be a rare occasion, and I'm sure the courts won't appreciate being bombarded with a series of JRs on an interim decision. But if you are unsure and you think that something needs to be heard now, or even if it is an interim decision, there's so much prejudice that it does need to be heard now by way of JR, then my view is file it within the 30 days and then ask the court for permission to either hold it in abeyance if you think it's not urgent, or alternatively, bring at the case conference your best case for why it needs to be heard expeditiously.
And then very similarly, I don't know if this is the same thing, where a tribunal allows for a reconsideration of its decision, what impact does that have on the time to file?
Very good question. And I think that the case law, to my knowledge, and I don't want anyone quoting me on this, but there's the first principle, which is that you have to exhaust all remedies before the lower tribunal, which means the reconsideration should happen and pass. But I do recall that I have found cases in the past that say that the reconsideration isn't essentially necessarily a review of the entire case, in which case you are duty bound to bring your appeal or JR within the prescribed time limits from the date of the original decision. So my suggestion is look at the case law governing your particular issue, because I do recall that this issue arose in my practice, I would say about 4 or 5 months ago, and I had to conduct some research, and I was surprised to learn that the court didn't think that that reconsideration step was a hurdle to commencing the particular appeal that I had to commence. So in other words, I had to commence it within the time frame from the original decision and not wait through the reconsideration and have that adjudicated.
And one last one, again, around the 30-day time limit, because this seems to loom large in people's minds. If you've missed the 30-day limit for filing judicial review, what do you do in terms of practical things to dealing with the court or opposing counsel or your insurance?
Yeah, it's actually an excellent question, Eric. There's a lot of things you have to do. I mean, the first is question whether or not you should be contacting your professional liability insurer at that point because you have blundered and you've missed a deadline. Separate and apart from that, you have to explain to your client that you've missed an important deadline, and the client may need independent legal advice from that perspective. Vis-a-vis opposing counsel, you could try to see if you could get their consent to extend, which should end the matter. But I say that with the caveat that a lot of counsel are under the impression that simply by getting consent to extend a deadline that the court's going to agree with you. They may not, and they may actually say that opposing counsel's consent is not determinative of their jurisdiction to extend the appeal or not, in which case the court may want to hear it and you'll have to bring a motion on regardless. So those are the sorts of factors that go into the calculus of what to do in the event that you do miss a deadline as the appellant or moving party.
Great. Well, Marco, I think that's all the time we have. We are a couple of minutes over. I do want to remind everybody that we are going to follow up with you, and maybe we can ask Marco to answer some of the questions we didn't get to in writing after that. Thank you, Marco, for such an informative, practical session with great advice for all of us. Thank you to Joan and the TLA for co-hosting with us today. And thank you to all of you for joining us for this session today. And we remind you to please, as you're signing out, to take our short survey to give us feedback on this, and we will be in touch with you as follow-up afterwards as well. Thank you. Thank you, Marco.
Great. Thank you. And thank you to all for attending. I really appreciate it. And thank you to LexisNexis and the TLA again. Thanks a lot.